$275. That's what it started as. A sticky note on my windshield disguised as an official notice. Then a certified letter. Then a lawsuit with my name on it in a county courthouse. By the time it ended, the HOA that sued me didn't exist anymore. Not as a suspended entity. Not as a will reorganize next year entity. Gone. Dissolved. Board members personally on the hook for 6 figures. And it all started because I didn't move my truck fast enough one Tuesday morning. Before I tell you how a $275 fine ended with an entire homeowners association wiped off the map, you need to know who I am, because the how of this story only makes sense once you understand the why. My name's Cole Bennett, 58 years old, 26 years as a forensic accountant, most of it doing fraud investigation work for insurance companies and 2 state attorney general's offices before I retired 18 months ago. My whole career was built on one skill: finding the sentence buried on page 41 of a document that changes everything about pages 1 through 40. People who lie for a living hate forensic accountants for exactly that reason. We don't argue with you. We just keep reading until we find the thing you were hoping nobody would read that far. My wife, Denise, runs a small bakery in town. We've got 2 grown kids, one in Nashville, one still local. We bought our place in Maple Crest Villas 9 years ago. 41 homes, gated, quiet, the kind of neighborhood where the biggest controversy most years is whether the pool committee should extend hours in August. I do woodworking on the side now that I've retired, built most of our kitchen cabinets myself, and I keep a 14-foot enclosed work trailer hitched to my F-250 for hauling lumber and finished pieces. That trailer is the whole reason we're here. For 9 years, nobody said a word about it. I'd park it in my driveway when I was between projects, sometimes overnight, sometimes for a few days if I was mid-build on something too big to fit in the garage. Then, 14 months ago, Sandra Pruitt got elected HOA president, and things that had been fine for 9 years started not being fine anymore. Sandra was 61, retired from a mid-level compliance role at a regional bank in Ohio before she and her husband Walt relocated here for the weather. She ran for the board on what she called a Restoring Standards platform, which mostly meant she'd spent her first year in office rewriting the architectural guidelines to be twice as long and issuing fines at a rate the previous 3 board presidents combined hadn't managed in a decade. She had a particular fondness for the word professional, used it the way some people use a hammer, and treated every disagreement at a board meeting as evidence that the other person simply didn't understand how communities like Maple Crest were supposed to function. The morning it started, I pulled the trailer into the driveway at 11 the night before after a job that ran late, planning to unload it first thing. By 8 the next morning, I had a bright yellow notice tucked under my windshield wiper. Violation notice. Commercial vehicle parked in residential driveway. Fine. $275. Payment due within 10 days. I want to be precise about something here because it matters enormously to everything that happened afterward. My truck and trailer are not commercial vehicles under any legal definition that applies to residential zoning or HOA governance in this state. No commercial plates. No advertising. No signage. It's a personal trailer owned by a private individual for a hobby. But more importantly than any of that, and this is the part that took me about 90 seconds to find once I actually sat down and read the documents I'd been handed at closing 9 years earlier and never looked at again. Maple Crest's own governing documents didn't authorize a fine of that size for a first violation of anything. I pulled the Declaration of Covenants, Conditions, and Restrictions out of the same fireproof box where I keep our passports and insurance policies, along with the HOA's bylaws and the state statute governing common interest communities, and I read every page of all 3 documents at my kitchen table with a cup of coffee and the particular patience that 26 years of fraud investigation teaches a person. The CC and RS, recorded and filed with the county in 2004, cap fines for a first violation of any kind of $50, with escalation to a maximum of $150 only after a documented hearing and a second offense. The state statute governing our type of association independently capped first offense fines at $75 unless the board had adopted a formal fine schedule through a properly noticed vote, and nothing in Maple Crest recorded meeting minutes, which I requested and received within the week, showed any such vote ever taking place. Sandra had simply decided, apparently sometime in her first 3 months in office, that $275 was an appropriate number, typed it on a letterhead, and started mailing it to anyone whose landscaping, driveway, or exterior paint didn't match her expanding sense of what professional should look like. I didn't pay it. I sent a certified letter instead, polite, 1 page, citing the exact clause in the CC and RS limiting first offense fines to $50, citing the state statute, and requesting the fine be reduced accordingly or rescinded entirely pending confirmation that any fine schedule had been properly adopted. I gave Sandra 30 days, more time than the statute required me to give her, because that's how you build a record that matters later. You give the other side every reasonable opportunity to do the right thing before you stop being reasonable. What came back 9 days later wasn't a corrected fine. It was a second notice. Late payment penalty added. New total, $425. And underneath it, a line I read 3 times because I genuinely couldn't believe someone had put it in writing. Continued noncompliance and refusal to engage professionally with the board may result in additional escalation as the board deems appropriate. Denise read it over my shoulder that evening. As the board deems appropriate, she said. That's not how any of this works, is it? No, I said. It very much is not. I want to be clear about something, because it's the thing that separates how I handled this from how most people handle an HOA dispute, and it's the thing that ultimately made all the difference. I didn't get angry, and I didn't get loud. I got organized. I opened a plain manila folder, labeled it Maple Crest, violation April 2nd, and started putting everything into it in the order I received it. The original notice, the certified letter I'd sent, and its return receipt. Sandra's response, a photograph of the trailer, dated, showing no commercial markings whatsoever. A copy of the recorded CC and RS with the $50 cap highlighted in yellow. A copy of the state statute with the corresponding section highlighted the same way. 26 years of fraud investigation teaches you that the case isn't won by being right. It's won by being able to prove you were right, in writing, in a sequence anyone can follow without you standing there to explain it. I didn't pay the $425 either. Instead, I did something I probably should have done from the very first notice. I walked over to Sandra's house on a Saturday morning, coffee in hand, and knocked on her door like a neighbor rather than a defendant. She answered in a cardigan, reading glasses pushed up into her hair, and smiled at me, the particular smile of someone who has already decided how a conversation is going to go before it starts. "Cole," she said, "I was hoping we'd get a chance to talk about this like adults." "That's exactly why I'm here," I said. "About the CC and RS with me, and the state statute. I think if you take a look, you'll see the fine schedule doesn't match what's actually recorded for this community." She didn't take the papers. "I appreciate you bringing that over, but the board has broad discretion to interpret and enforce community standards. That's what a professional board does. We can't have every resident who disagrees with a fine showing up with their own reading of a 20-year-old document." "It's not my reading," I said. "It's the recorded document. $50 for a first offense. Your letter said $275. The board felt $50 wasn't a meaningful deterrent," Sandra said, still smiling. "So we've been applying a figure more consistent with comparable communities in the area." "Was that change ever voted on? Noticed to the membership? Recorded anywhere?" For just a fraction of a second, something flickered behind her expression, gone as quickly as it appeared. "I don't see why that level of procedural detail is necessary for you to simply comply with a reasonable request, Cole. I'd hate for this to become more complicated than it needs to be." I left the papers on her porch table anyway, thanked her for her time, and walked home thinking about the particular tone people use right before they threaten you without technically threatening you. Denise was right about one thing that whole spring. Sandra Pruitt was not a woman who had ever once, in her entire adult life, been told no and simply accepted it. 3 weeks later, a lien notice arrived. Sandra's board had voted 4-1, Trent Iverson the lone dissent, a fact I only learned later mattered a great deal, to authorize filing a lien against my property for the outstanding balance. Now $425 plus a $150 administrative processing fee the association had apparently invented sometime between the second and third notices, bringing the total to $575 over what had started as a trailer parked in a driveway overnight. I want to pause here on something Sandra did that weekend, because it's the moment this stopped being purely about me. She sent an HOA-wide email. I still have it, forwarded to me by 3 separate neighbors within the hour, titled A Reminder About Community Standards and Respect for Process, which didn't name me directly but described, in language specific enough that everyone in the neighborhood knew exactly who she meant. A resident who has chosen confrontation over cooperation and whose continued defiance threatens the financial stability of our reserves through unnecessary legal exposure. She closed the email by announcing that, effective immediately, all first-time violations would carry an automatic $275 fine to properly reflect the administrative cost of enforcement in a community where some residents refuse to comply voluntarily. She had just publicly admitted in writing to every homeowner in Maple Crest that the fine amount had never been based on any adopted schedule at all, that it was, by her own words, a number she was now retroactively justifying because of me specifically. I forwarded that email in my folder within the hour and highlighted the phrase, properly reflect the administrative cost, so hard the paper nearly tore. It didn't stop with the email. Over the following 2 weeks, 3 other households received their own violation notices, all for things that had sat untouched for years without comment. A basketball hoop that had stood in the Kowalski driveway since their son was in middle school, now a junior at state, cited for unapproved permanent fixture. A wind chime on the Ferraro's porch, cited for excessive ambient noise inconsistent with community tranquility standards, a phrase I'm fairly certain Sandra invented on the spot because it appears nowhere in any version of the governing documents I by then read closely enough to recite from memory. Each fine was $275. Each one arrived within days of a resident being seen talking to me at the mailbox or the community pool. Rosalind Kowalski called me in tears one evening, not because of the fine itself, which her husband could easily afford, but because Sandra had stopped her in the parking lot outside the clubhouse and told her, in front of 2 other residents, that some people seemed determined to make this community difficult for everyone, and I'd hate to see good neighbors caught in the crossfire of somebody else's grudge. Rosalind hadn't done anything except wave to me once across the street. I added the pattern to my folder. 4 fines, all $275, all issued within a 6-week window that began the week I sent my first certified letter, 3 of them targeting residents with a documented connection to me. 26 years of fraud work teaches you that a pattern like that isn't a coincidence you note and set aside. It's evidence of intent, and intent is the thing that turns a sloppy administrative error into something a judge takes considerably more seriously. The trailer got keyed the same week the 4th fine went out. Long scratch down the driver's side panel, deep enough to need a full repaint. No witnesses, no note. I installed a doorbell camera the next morning, less out of any real expectation it would catch anything and more out of the same instinct that had me keeping every letter in a labeled folder. The instinct that says document first, react later, because the moment always comes when someone needs to see exactly what happened and exactly when. The camera never caught anyone touching the trailer again. It did catch, 3 weeks after installation, a car I didn't recognize idling at the curb outside my house for 11 minutes at 10 at night before pulling away. Plate number Renata later confirmed, through nothing more exotic than a public vehicle registration lookup, was registered to Walt Pruitt, Sandra's husband. I never proved he'd been the one who keyed the trailer. I never needed to. I only needed the timeline sitting quietly in my folder, next to everything else, waiting for the moment it would matter. Trent Iverson called me 2 nights later. He'd been the HOA's treasurer for 6 years before Sandra's slate swept the board, and he'd been voted off the finance committee entirely, replaced by a resident named Colleen Marsh who, as it happened, ran a part-time bookkeeping business out of her home and had, according to Trent, been paid $1,800 over the prior 4 months for administrative support services that had never gone through a competitive bid or board vote he could find any record of. I'm not calling to get involved in your dispute. Trent said. I'm calling because I think you're the only person in this neighborhood with the patience to actually do something about what's happening with the books. I told him I appreciated it, and that I'd be in touch once I understood the full shape of what I was dealing with. That's the other thing 26 years of fraud work teaches you. You never move on partial information. You wait until you understand the entire structure of what's actually happening before you make your first real move. Because the person doing the wrong thing will almost always keep doing more of it while you wait, and every additional thing they do becomes one more piece of evidence working in your favor. Before any of that reached a courtroom, there was one more meeting. Sandra called it herself, an emergency community session held in the clubhouse on a Wednesday evening in late March, ostensibly to discuss reserve fund planning, but which everyone in the room, myself included, understood within about 90 seconds to actually be about me. The clubhouse smelled like the same burnt coffee every HOA clubhouse in America apparently smells like, and every folding chair was full, more people than I'd seen at a Maple Crest meeting in 9 years of living there. Sandra stood at the front with a printed agenda and opened by describing, without naming me directly, a resident whose ongoing legal posturing threatens to drain reserves meant for actual community improvements, and framed the upcoming lawsuit as something the board had been left no choice but to pursue to protect the financial interests of every household here. When she opened the floor for comments, I stood. I'd like to ask the board a simple question, I said, since we're discussing reserve funds tonight. Has anyone here seen a copy of the fine schedule that authorizes a $275 first offense fine? Not the number in a letter. The actual adopted schedule, voted on, noticed to the membership, and recorded the way our bylaws require. Silence. Sandra's smile didn't move, but her hand, resting on the podium, tightened just slightly around the edge of it. The board has broad enforcement discretion, as I've explained to Mr. Bennett directly on more than one occasion. That's not what I asked, I said. I asked whether anyone in this room has seen the vote. Trent Iverson, sitting 3 rows back, raised his hand slowly. I was treasurer for 6 years before this board took over, he said. I've never seen that vote, either. The murmur that ran through the room after that was the first sound all evening that wasn't coming from Sandra, and I watched her recalibrate in real time, the particular expression of someone doing quiet arithmetic on how many people in the room she could still count on if this went the direction it was clearly starting to go. She adjourned the meeting 11 minutes early, citing other pressing board business, and the lawsuit papers arrived at my house 9 days later. The lawsuit arrived on a Thursday in April, filed in county court by an attorney named Peyton Wexler on behalf of the Maple Crest Villas Homeowners Association, seeking $575 in unpaid fines, $1,200 in the association's legal fees for filing the action, and a judgment authorizing foreclosure proceedings on the lien if the full amount, now $1,775, wasn't satisfied within 30 days of judgment. They were suing to take my house over a trailer. I called an attorney myself the following morning, a woman named Renata Vasquez who'd spent 11 years doing HOA and common interest community litigation before going into private practice, specifically because, as she told me during our first call, I got tired of watching boards bully retirees who didn't know they had rights. I laid out everything: the CCNR cap, the statute, Sandra's own email admitting the fine schedule was invented after the fact, the lien vote, the lawsuit itself. Renata was quiet for a moment after I finished. Cole, she said, I need you to email me every single one of those documents this afternoon because I think we're going to countersue, and I think we're going to win. What Renata found over the following 2 weeks turned what I'd assumed was a straightforward defense into something considerably larger. Colorado, like most states, requires nonprofit corporations, including homeowners associations organized as nonprofit corporations, to file an annual periodic report with the Secretary of State's office to maintain active status. It's a simple filing, usually a formality, the kind of administrative task that sits quietly in the background of an organization's life and rarely matters to anyone. Renata pulled Maple Crest Villas Homeowners Association's corporate filing history from the Secretary of State's Public Business Registry. The same 2-minute public record search that had cracked open more than one HOA scandal I'd since heard about from friends who followed this kind of thing online, and found that the association's corporate status had lapsed into administrative dissolution 11 months earlier, 7 months before Sandra's board ever voted to authorize the fine schedule, increase, the lien, or the lawsuit against me. "Cole," Renata said on our call, and I could hear something close to genuine excitement under her professional calm. An administratively dissolved corporation in this state cannot legally conduct corporate business. It can't vote on new policy. It can't authorize fines under an unadopted schedule. It absolutely cannot file a lawsuit in its own corporate name, because as far as the state is concerned, that corporate name doesn't legally exist right now. Every single action this board has taken for the past 11 months, the fine increase, the lien, the lawsuit currently sitting on a judge's desk, was taken by a corporation that didn't have the legal capacity to take it. I sat with that for a long moment. 26 years of finding the sentence on page 41, and this one had been sitting in a public database the entire time, available to anyone willing to spend 2 minutes looking, exactly the way the water rights records and the LLC filings and the plat surveys always seem to be sitting there waiting in every story like this one. Not hidden, just never checked, because the people relying on their own authority rarely stop to ask whether that authority still legally exists. Why would nobody have caught this? I asked. Because dissolution notices go to whatever address is on file with the state, Renata said, and if nobody's checking the mail at that address, or if the registered agent moved and never updated it, the whole thing just quietly lapses. Happens more than you'd think. Small nonprofits, HOAs especially, because boards turn over every year or two and nobody thinks to check something this dry, unless they have a specific reason to look. I had a specific reason to look now. Renata filed our answer and counterclaim within the week. A motion to dismiss the HOA's lawsuit entirely on the grounds that the association lacked legal capacity to sue while administratively dissolved, alongside a counterclaim on my behalf for the improperly imposed fines for the costs I'd incurred defending an action the association had no legal standing to bring. And this was the part that would matter most later. A request that the court examine whether individual board members could be held personally liable for actions taken on behalf of a corporate entity that legally hadn't existed at the time those actions were taken, a doctrine Renata explained applied specifically because Colorado's corporate shield only protects board members acting within a validly operating corporation. Once the corporate veil disappears because the corporation itself has lapsed, the protection built into that structure lapses along with it. Sandra's response, once she learned about the motion, was not to quietly settle. It was to escalate again, in the particular way people escalate when they've never once been told no and don't yet understand that this time is different. She sent another HOA-wide email accusing me of using legal technicalities to avoid accountability for years of noncompliance. Organized what she called an emergency board meeting to address ongoing legal threats to the community. And this detail, when I finally learned about it, was the one that made even Renata pause mid-sentence on our next call. Authorized, apparently on her own signature alone, an additional $4,500 in emergency legal retainer funds to Peyton Wexler's firm to fight. The motion to dismiss, drawn from the HOA's reserve account, an account that, as it turned out, thanks to Trent Iverson quietly pulling 6 months of bank statements before he'd even fully understood what he was looking for and handing them to Renata the following week, had also been the source of $1,800 in unauthorized payments to Colleen Marsh's bookkeeping business, $2,200 in catering costs for what the ledger described only as board appreciation events, and a curious $3,000 payment made out directly to a company called Pruitt Property Consulting, which the Secretary of State's registry, that same 2-minute search, showed had been registered 4 months earlier, sole owner and registered agent, Sandra Pruitt. I read that line in Renata's email 3 times before I called Denise into the room to read it herself. She's paying herself out of the fines, Denise said. She's paying herself out of everything, I said. The hearing on the motion to dismiss was scheduled for late June, In a courtroom I'd walked past 100 times over the years doing fraud investigation work for the AG's office, but never once sat in as a party myself. I wore a plain gray suit. Renata carried a single expandable folder, considerably thinner than I'd expected given everything it contained, because that's the thing about a genuinely strong case. You don't need volume, you need the 2 or 3 documents that end the argument before it really starts. Peyton Wexler opened by arguing that the dissolution was a minor administrative lapse that shouldn't invalidate a board's good faith actions on behalf of the community it represented, of framing Judge Elena Marsh. No relation, as she dryly noted for the record, to Colleen Marsh, a coincidence that got a small ripple of laughter from the gallery, which had filled with more Maple Crest residents than I think either side had expected, word having clearly spread through the neighborhood by then. Judge Marsh let Wexler finish, then asked a single question before Renata had even risen from her chair. "Counsel, does Colorado law provide any exception allowing an administratively dissolved corporation to initiate civil litigation in its own name, provided the underlying cause it's litigating is meritorious?" Wexler hesitated. "Your Honor, we'd argue the equities of the situation favor." "That's not what I asked," Judge Marsh said. "I asked whether the statute provides an exception. Yes or no?" "No, Your Honor. Not explicitly." "Then we're not really discussing equities yet, are we?" she said, and made a small note on the pad in front of her. I watched Sandra, 2 seats down at the plaintiff's table, go very still in the particular way people go still when they realize the room has already started tilting away from them and there isn't yet anything they can do to right it. Renata stood, and she didn't raise her voice, and she didn't need more than about 6 minutes. She walked the judge through the dissolution date, the timeline of every board action taken after it, the CC&R fine cap, the never-adopted fine schedule, Sandra's own email admitting the $275 figure had been invented after the fact specifically in response to my refusal to pay, and finally, the 3 payments, to Colleen Marsh, to the catering vendor with no competitive bid on record, and to Pruitt Property Consulting, all authorized by a board acting under a corporate name the state of Colorado had, for the entire relevant period, considered legally non-existent. "Your Honor," Renata said, closing, "the plaintiff is asking this court to enforce fines, a lien, and a lawsuit generated entirely by an entity that had no legal capacity to generate any of them, while that same entity's president was simultaneously directing association funds to a company she personally owns. We're asking the court not only to dismiss the underlying action, but to grant the counterclaim in full, and to make a finding on personal liability given the clear absence of any functioning corporate shield during the relevant period." Judge Marsh took a recess of just under 20 minutes. When she came back, she didn't spend long on it. The motion to dismiss was granted. The lien was voided retroactively, as having never had legal authority behind it. The counterclaim was granted in substantial part, with a further hearing scheduled to determine final damages and the question of personal liability, which she noted, looking directly at Sandra for the first time all morning, given the record before me today, appears considerably more likely than not to attach. Sandra did not look at anyone on her way out of the courtroom. Marlene Otts, the board's secretary, resigned the day after the dismissal ruling, and unlike Sandra, she called me directly before she did it. I almost didn't pick up when I saw the number. "I kept the real minutes," she said, without much preamble, once I answered. "Not the cleaned-up versions Sandra sent out to the neighborhood. My actual handwritten notes from every meeting since she took over. I've got them in a drawer at home. I didn't know what to do with them until now." We met at a diner off the highway 2 days later, and she slid a spiral notebook across the table the same unceremonious way I imagine most damning evidence in the history of small local disputes has changed hands. Over bad coffee, in a booth, by someone who'd simply run out of reasons to keep protecting the person they'd once believed in. The notes showed exactly what Trent's bank statements had only implied. Sandra proposing the Pruitt Property Consulting contract herself, seconding her own motion after no one else would, and instructing Marlene directly, in a meeting 8 months earlier, to keep the language in the official minutes general regarding the vendor payments. so we don't invite unnecessary questions from residents who don't understand how these things work. I handed the notebook to Renata the same afternoon. The damages hearing 6 weeks later turned into something closer to a full accounting of Sandra Pruitt's 14 months in office than either side, I think, had originally expected it to become. Trent's bank statements, combined with a formal audit the interim board, 3 of the original 5 members had resigned within days of the dismissal ruling. Faced with a recall petition that had gathered signatures from 34 of Maple Crest's 41 households in under a week, commissioned that summer, showed a total of just over $19,000 in association funds directed either to Sandra personally through Pruitt Property Consulting, to Colleen Marsh without competitive bid or proper board authorization, or to legal fees spent fighting a lawsuit the association had never had the legal standing to bring in the first place. The court's final order held Sandra Pruitt, and to a lesser degree, given her more limited direct involvement, Board Secretary Marlene Otts, personally liable for the improperly authorized payments, the wrongful lien, and Renata's fees for the entire proceeding, a total judgment against Sandra individually of just over $61,000. The Maple Crest Villas Homeowners Association itself, given the extent of the dissolution issue, the unwound corporate authority, and the sheer administrative mess of untangling 14 months of invalid board action, was formally and permanently dissolved by the interim board's own vote 3 months later, its remaining assets distributed back to the 41-member households, and its functions reorganized under a new, properly filed nonprofit corporation with a new board, new bylaws capped exactly at the state's statutory fine limits, and a standing rule adopted unanimously at the reorganization meeting, requiring an annual public reading of the association's Secretary of State filing status at every yearly meeting from that point forward. Trent Iverson became the new board's first treasurer again. He asked me, only half joking, whether I'd consider running for the board myself, given everything I now apparently knew about how these things actually worked. I told him I'd think about it. And mostly I meant I'd think about anything except ever again wanted to spend a Tuesday evening in a room with a laminated meeting agenda. I still have the trailer. It still sits in my driveway sometimes, overnight, unbothered, exactly the way it did for the 9 years before Sandra Pruitt decided $275 sounded like an appropriately professional number. I kept the original violation notice, the sticky note yellow one from the very first morning, in the same manila folder that eventually grew thick enough to need a rubber band, and I framed it, small and plain, and hung it in my garage above the workbench where I do most of my building now. Denise asked me once why I bothered keeping it instead of just throwing it out once the whole thing was finally over. Because it's a $275 fine, I told her that ended up costing Sonny $61,000 and an entire homeowners association, and I think that's worth remembering exactly how it started every single time I walk past it. She didn't argue with that. Nobody who's ever actually read the documents ever does. The new board, in its first full year, did something the old one never once bothered with. It held a short annual workshop, open to every household, walking residents through exactly how to read their own CC and RS, how to check a board's corporate standing on the Secretary of State's website, and how to request meeting minutes if something ever fell off. Trent asked me to help put it together, and I said yes before he'd finished the sentence. Mostly because I kept thinking about Rosalind Kowalski crying in a parking lot over a basketball hoop that had stood there peacefully for a decade, and about how much of what happened to all of us could have been avoided if anybody had simply known to look 2 minutes earlier. 11 households showed up the first year. Rosalind was one of them, sitting in the front row with a notebook, asking sharper questions than half the people who'd actually served on a board. I don't know if it'll matter to anyone else the way it mattered to us. But I know that somewhere in a filing cabinet in that clubhouse now sits a laminated 1-page guide titled 5 Things to Check Before You Pay Any HOA Fine, and every single item on it is something I learned the hard way, at a kitchen table over a $275 sticky note that somebody thought I'd never bother to read past the first line. Turns out I always read past the first line. That was kind of the whole job for 26 years. Sandra Pruitt just happened to be the last person who found out the hard way that I never really stopped doing it.